Good morning. Welcome to Lunch with Don, or Water with Don, or whatever you have in front of you, Snack with Don, or granola bar, or whatever. This is our weekly Q&A session, and so you're welcome to type in your questions, and let's see what we can do for a half an hour to hit them. And so if you've got questions, you're welcome to ask them. We had a webinar on Tuesday night with John Anderson was our guest speaker. John is an estate planning attorney, and he's the head of the estate planning department for Anderson Business Advisors. And there were hundreds of questions, and there is no way we could get to them all. So we thought while you're plugging in and asking questions, your questions here will take priority. But until then, I wanted to answer some questions about estate planning that were somewhat basic, that you know, when we've been teaching this for 20-something years, you kind of forget that what's basic to me is not basic to everyone who's trying to learn the system. We understand that this is a new a trust, a will, these are legal concepts that are not new, or that are very new to some people, and it's like learning a new language. And so let me break this down a little bit. What we're doing when we create it, first of all, a will is directions to the probate court. Well, what is probate? Maybe we start with that. Probate is the process of figuring out, for use, no legal terms here, let's cut to the chase. Probate is the process of figuring out who gets your stuff if there's not clear title to it when you die. So I die, and I own a house. It's in my name. Who now owns the house? Well, and without a will or directions or a trust or some type of directions as to who we want to own this, it's going to go through probate. And probate can be timely, very. There are some estates that have taken decades to go through probate. The expense normally, or the time average, is 18 months in America to go through and probate an estate. But the average person in America dies fairly broke too. And so if you've acquired any wealth, it's probably going to take a whole bunch longer. So that's the time. The expense, figure on average 5 to 10% of your assets, of your net worth. That includes life insurance, that includes the equity in your homes and your retirement accounts and everything. Put it in one big pile, take 5 to 10% off to figure out who gets what, because, and that's assuming that there's not a lot of fights and disputes over it. That's assuming that it's fairly clear cut. When there's fights and disputes, then court costs and legal fees can add up significantly. So, and then everything that you do, everything that goes through probate becomes a matter of public record. And so anybody can go through and find out who got what out of your estate, who, you know, what you owned. And so for the most part, I think it's really a good idea to avoid probate. Now, one of my instructors way back when always said that we always want one asset to go through probate. To pick one little asset, like a vehicle or a small bank account. The probate process, it's Old English law. You know, hear ye, Kendall has died. Sorry, Kendall. And so if anybody has any claims against his estate, or if there's any heirs, bring them forward, and then let's settle this now. Let's pay all the debts. Pay anything that's owed, and then distribute. That was the process of probate. And the reason Jay Minton used to always like one asset to go through probate, let's clean everything up, but take one asset, because it stops all judgments against that estate for now and forever. And so he didn't like big assets go through it because of the time, the expense, and the matter of public record. But he always wanted one asset to go through to stop, you know, any claims against the estate. I think that that's a good idea. So our goal in most most estates is to avoid estate taxes, to avoid probate. So a will is directions to the probate court of what to do with your estate. And a lot of people go, well, I have a will. Okay, so those assets will go through probate, and 25% of the time your will be contested. And so we really like trusts if it makes sense, if the assets are sufficient. If you die completely broke and there's nothing to probate, then obviously we don't need a trust. But if we've got a very small amount, maybe a will is sufficient. But once we've acquired any assets, we, for the most part, we'd like revocable living trusts. And so what goes into the trust? Picture this. All of you have a big popcorn Tupperware bowl somewhere in the house. That's a great analogy that I like to use, but you never take that popcorn Tupperware and put it in the cabinet empty. Maybe it's a great big salad bowl, I don't know, whatever. But you always put all the little Tupperware bowls, the little salad bowls inside. You nest them inside, then you put it away. A trust is very much like that. Here's my estate. Yes, I own a corporation, but the stock of the corporation has been retitled or titled in the name of the trust, so that when I die, there's clear succession for the stock of my corporation. Yes, I own a limited partnership or an LLC, but my interest of that is tied to my trust. Yes, I own a home, but that was retitled in the trust. My bank accounts were titled in the trust. The trust is really a disregarded, non-existent entity until we die. But once we die, then there's clear title, because you don't own the house, the trust does. And the trust continues on. You died, but the trust didn't die. And there'll be a new trustee that you picked, a successor trustee, or maybe a series of people in succession. For my parents' trust, my wife or my sister and I are co-trustees. We have to agree on everything. Both my parents are deceased, and so me and my sister agree on most things. And until we reach agreement, she can veto me or I can veto her. And so that's worked out really well for our family. So what goes into the trust? Well, anything you want to avoid probate. There are a couple things we can't put into a trust. We can't put children into a trust. We can't retitle the kids in the name of the trust. So the will picks up anything that the trust didn't do. So in the will, that's where we provide guardianship for minor children. In the will, we provide for the pets. In the will, there's a pour-over provision that says, oh yeah, we forgot to put that in the trust. It looks over, scans over, pours over your entire estate and goes, yeah, let's put that in the trust too. Now that asset might go through probate, but it'll be an easier probate because the last will and testament and the pour-over provision says the trustee gets to control it. And so, do we need both? In most cases, yes. We still need, even if I don't have minor children, we still need the pour-over provision. In anything that the trust can't own, then the will takes care of. I hope that makes sense. Next question was, is this filed with any state agency? A trust is not filed with any state agency. The only exception to that I know of is Idaho. They like revocable living trusts filed with the county recorder, and so for it to be legal. That's the only state that I know. But other than that, the trust is not, it's not a matter of public record, so we don't file it with the state agency. It's not like a business entity, a corporation, limited partnership, LLC. It's a private document that really nobody's going to see other than the family members. I think it's a good idea for the family members, especially for the beneficiaries, to get a copy of the trust in advance. I think it's a good idea so that one person doesn't control it and nobody else knows what's going on. Well, again, with my parents, all of the 5 kids received a copy of the trust. years in advance of when it was needed. Here's what mom and dad want. There were no surprises, no Hollywood drama. Oh my gosh, I get $300 out of it. No, everybody knew what was happening. And there were medical powers of attorney, there were financial powers of attorney. Everything was in place so that there's no disputes over what mom and dad wanted. That to me is a good plan. Who else needs a copy of the trust? The successor trustees. Generally, when you set up a revocable living trust, you're going to be the trustor, the settlor, the grantor. It's the person who sets up, creates, funds the trust. That's the trustor. Then there's a trustee. That's the person who runs the trust. After the assets are gifted to the trust or conveyed to the trustor's job is over. He set up the trust and funded it. He put stuff in. Now the trustee runs the trust. And there might be successor trustees. It might be, if it's a husband and wife, they might be co-trustees. When one passes away, the other assumes the role. Then the successor trustees, and you can have several in succession. If this person is unable to be the trustee, then that kicks in. And then there's beneficiaries. Beneficiaries are the people who receive the benefit from the trust. Initially, you're going to be the beneficiary of the trust, but eventually you're going to have contingent beneficiaries. These are the people, generally the kids or the grandkids, who I'm not around anymore, so somebody's going to receive the benefit, and that would generally be the contingent beneficiaries. Are there ongoing costs to a trust? And the answer is no. There's no state filing fee like a corporation or limited partnership or LLC because it's not filed. However, as assets change, I sold a car and I bought a piece of property. There might be funding documents, a recording fee to transfer real estate. There might be a real estate transfer tax, but there's no ongoing annual fees for a trust. After mom and dad die, after the trustors have passed away, there might be trustee fees for the successor trustees to continue to run the trust. Kendall, are we getting any questions here?
People just are really loving it, for sure. I think that the biggest question we get all the time is, does everyone need a trust? That's only for multimillionaires, so I don't need a trust.
Yeah, and that. My my mother-in-law passed away, and it was in California, and she really didn't have a lot other than real estate. She had the house, and very little else. Okay, she had a lot of junk in the house, and we had to clear that out. Oh my gosh, what a hoarder! But my wife's not listening, I don't think. So that's good. I'm
telling.
Lots of stuff, but nothing really valuable. She had a small bank account. She had no retirement accounts. But that took over 2 years to probate that estate because there was no will, there was no trust. Would a trust have been helpful for that? Oh, absolutely. If we had had a trust for that, then immediately, the day after she dies, or the minute after she dies, the new trustee kicks in and can sell the house, can fix up the house, can repair the house, can do whatever, takes over all the bank accounts, and it would have been very, very clean. Oh my gosh. So I kind of disagree with that. Now, can the cost of setting up the trust be prohibitive? Normally, you're looking at $2,000 to $4,000 to set up a trust and fund it properly. Most attorneys, let me tell you a quick little secret, most attorneys that set up trusts never fund them. They don't put any assets into it. They create the document, and then on page 57 it says, oh, by the way, it would be probably a good idea for you to fund it. Here's how to do it, but we're not going to do it to save you money on legal fees. And that's not always the case. Sometimes they don't fund it so that they do eventually get to walk all those assets through probate, because the trust can only control that which it owns. If you never put the assets into the trust, they will go through probate, especially real estate. And so not only is setting up and creating the actual trust document important, but the funding documents as well. Any other questions?
Yeah, and I think just to add to that, if you don't think your estate's worth it, for sure, life insurance, people don't usually count. That counts, and that adds up fast.
Well, yeah. Now, life insurance, it will count to your estate taxes, but there's generally a beneficiary, and so life insurance doesn't generally go through probate. Let's say I've got a life insurance policy and I've listed my wife as the beneficiary and my kids as contingent beneficiary if my wife's not around. Okay, there's very clear succession to that. But what happens if all I've listed is my wife and she's not there? She either passed away, she predeceased me, or maybe we died at the same time or something. And then now there's no contingents, or the contingents, I don't know, whatever, aren't there IRAs. We run into that. And there's clear succession for that if the beneficiary is still alive. And so it's a good idea with any trust to make sure to update these once in a while with the current assets. What are the new properties you've purchased, the new LLCs you've created, the new corporations, the new bank accounts, brokerage accounts. Make sure that those are funded, and an annual review is really a good idea. I personally like to do it right around tax time when I've got all my records out, and that's a good time to look at my trust and make sure that it's up to date. Some people pick, January 1st or their birthday or an anniversary date or something, but an annual review of your trust funding documents, I think, is a really, really good idea.
And it's not just that, too. It's if you have minor children, that's a big deal. And even distributing to your grandchildren.
Well, that's very true. We have, you get 3 grandchildren. Oh, wait, we have 4. Do I need to change the trust? Do I not need to change the trust? Kendall, you've got young kids, and, you're ready to add, child number 13 now? And
Feels like it.
No, but if we have more children, then we need to change the trust document and make sure that they're listed as beneficiaries or contingent beneficiaries, whatever we need to do. All right, one of the questions we get often is, if I move from a different state, do I need to amend the trust? And the answer is yes, probably so. Everywhere in the trust, in multiple places, it will say something like, this trust has to abide by all of the laws of, then there's a blank line. And if you put Arkansas, and throughout that trust document, 57 times it says that, this is applicable to the laws of Arkansas, and you move from Arkansas to Pennsylvania, then we probably ought to change that, scratch that and go Pennsylvania or whatever. Or simply amend the trust, restate it, but the trust will not be state specific other than the mention of the state, all laws applicable to the state of whatever that will be in there, and rarely would a regular trust not in another state. Does it need to be notarized? Yes, your trust would need to be notarized. It would need to be signed and notarized. In some states, it would have to be witnessed. But that's and one of the questions we got. We have been selling trust documents in our package for years and years and years, and so there's a. And one of the questions came from one of our students who has our legal software and wants to set up their own trust, but what's prohibited him from doing that is he doesn't know if it needs to be notarized or not. So for years he's never set up his own trust. Well, okay, at the bottom of all of our documents, it says sign here, or maybe it doesn't say sign here. Maybe it says notarize here, and we left a place. If it says notarize here on our documents, then get it notarized. And if it doesn't say that, then you don't have to. And at the back of our textbook, there's a chart. It's an Excel sheet. It's a big graph. Every one of the legal forms that we offer in one side, and then then there's a little graph. Does it need to be signed? Does it need to be notarized? Does it need to be filed with any state agency? Look at the graph, go, oh, yep, this needs to be signed. How often does my trust need to be set to be, addressed? And again, I mentioned at least annually, check the funding documents. But what that means is the trust itself probably won't change from year to year to year. Oh, it could if there's been a divorce, or maybe I've had I've had more kids, but generally the trust doesn't change. The only thing that would be required to change is the funding documents. And what we do is we take our trust and we slap on a little piece of paper at the end and say, here's the Schedule A, here's the Exhibit A, here's what the trust owns. It's an inventory list. And that might not need to be changed annually, and if so, you change the Schedule A annually, go down and get that signed and notarized. Your bank could do that generally for free. But don't change the trust, simply change the Exhibit A or the Schedule A to the trust. Here's what the trust owns. And that would be most common.
And is it bad? I mean, what if they got everything notarized? Awesome, right?
Well,
it doesn't matter. I mean, when in doubt, do it. I don't think that's a problem.
No, and in fact, people will ask me all the time, my corporate minutes, do they need to be notarized? No. But you could. It wouldn't hurt to do it. It would keep anybody from accusing you of going back and backdating stuff and saying you made this up after the fact. Well, that's true, and having a notarized stamp would do that, but there's a lot of things that aren't necessary to notarize. But the Schedule A, the transfer of assets into the trust, yes, that would have to be notarized.
Yeah.
Okay. Were there any other questions, or do you want me to just kind of keep reading? Okay. Talk to us about irrevocable trusts, and what's the difference between revocable and irrevocable trusts? An irrevocable trust is just that. You're pouring wet concrete. You're setting up something that will not change. And when you transfer the assets or convey the assets or gift the assets to the trust, you don't own them anymore, and they're not yours. And so any claim of ownership to them doesn't have to be recognized. And generally when we're doing an irrevocable trust, we're giving somebody else trustee powers. We don't, as an organization, we don't use a lot of irrevocable trusts because, for estate planning purposes at least, because they're irrevocable. You can't change them. And frankly, life changes. There's too many things that happen. Kids get in bad marriages. There's deaths, there's illnesses, there's divorces, there's marriages. Life changes too fast. We like having assets that are valuable in limited partnerships and LLCs. We like to manage things through corporations. Everything flows down into your big Tupperware bowl that is revocable and amendable and changeable. But an irrevocable trust, again, is irrevocable. But because it's irrevocable, and I've put the assets in an irrevocable trust, it takes it out of my taxable estate, so there's no estate taxes on that. An irrevocable trust will require a tax return annually, but there is a degree of asset protection with that, depending on how much control you want to assert over this. If this is truly an arm's length transaction, and I can't just go get money anytime I want to out of the irrevocable trust, then there's a good degree of asset protection. But if I can call up the trustee anytime and say, hey, I need a few $1,000s, anytime I want to, if you have access to those assets, a judgment creditor against you could also get access to those. And so the asset protection that comes with irrevocable trusts is questionable at best depending on your access to the assets. There are all types of marketing people out there right now that are pushing irrevocable trusts. And let me tell you, it's a marketing gimmick. And they say, well, this is a flexible protective trust, or this is a dynasty trust, or this is, what they're doing is they're taking one clause. This is a generation skipping trust. All they're doing is they're taking one paragraph out of the trust, and they're, for marketing purposes, they're going, oh, this is the name of the trust. And this is a special needs trust. This is an AB marital trust. This is I don't know, whatever they want to call it. It's a market. A trust is a trust is a trust is a trust. It has a trustor, it has a beneficiary, it has a trustee. It's either revocable or non-revocable, and the rest of that is all marketing. That's all it is. And we can call it whatever. We can call it a land trust. We can call it a business trust. We can call it a whatever kind of trust. An RV trust for my RV. We can call it, I don't. There was a time when people wanted us to put together a Iraqi dinar trust and market this as an Iraqi dinar trust. So we gave them a regular trust and the only thing we changed was the title, and we added a little paragraph to own Iraqi dinar. But I don't go for the marketing crap that goes with
trust.
it.
Here we go.
We could do a Bitcoin trust, absolutely. And it could be revocable or irrevocable, but it's still going to have three parties. Remember, a trust is a trust is a trust is a trust. It's a way of holding assets and all trusts will avoid probate. There's clear succession because, remember, you died, but the trust didn't. And then we simply follow, the new trustee simply follows the terms of the trust. Who owns the trust? It would be the beneficiaries. Could they, if they don't like what's going on, could they get together, gang up, and kick out the trustee? Yes, with a little court help, a little help from the attorneys. Yes, they could. I hope this has been helpful.
You got one question.
Yes.
If you only put your home or a home into a land trust, do you make your living trust the beneficiary?
We could, although the land trust, remember, it's simply a trust. It's a revocable grantor trust, same as a living trust. And if the beneficiaries are clear and you want it to go to everybody that you want it to go to, then there's no need to tie it into a trust. But yes, what I could do is if I've got a piece of property in a land trust, I could assign the beneficial interest or the ownership to my revocable living trust, so that my revocable living trust owns the land trust. Remember, though, that a revocable living trust doesn't provide asset protection. Because, again, it's revocable, it's amendable. I can move the assets in and out and in and out and in and out. And as long as you have access to those assets, so does a judgment creditor. A land trust is a great smokescreen, but it's not a good asset protection plan. So normally what we would do is we'd put that land trust into an LLC, and then the ownership of the LLC falls into our revocable living trust. If that's a personal residence, that might be a little different, but if it's an investment property, we like the LLC as a stopgap in the middle. Now if somebody sues you, they can't take that away. They can't take the LLC away. They would run into a charging order. We hope that this has been helpful. If you're always welcome to contact us. Our phone number for Protect Wealth Academy is all over our website, but it's 800-276-1430. If you have questions, you can always email them to info. Is that right? Info?
Support.
Oh, support.
At Protect Wealth.
Support at protectwealth.com. We welcome your questions. We've been doing this a long time. We've run a hotline for, I don't know how many, over 2 decades. We're happy to answer questions, but also this is just such a tip of the iceberg of what we teach at our 3-day asset protection summits. Go to our website. If you haven't attended one of our summits, make sure you do that. Thank you for being on. Have a great day.